acknowledge the traditional custodians of this land on the Gadigal people of the Eora Nation. And I want to pay my respects to elders past and present, and to extend that to any Aboriginal people and elders with us today. So today, this webinar is the third in a series to introduce participants to accountability mechanisms in the United Nations that hold states accountable to their human rights commitments. And so what we're looking at today is the UN special procedures, one of which of those is the Special Rapporteurs, who act on individual cases of alleged violations and concerns of a broader structural nature by sending communications to states. They can also undertake country visits, conduct thematic studies, and convene expert consultations, and contribute to the development of international human rights standards, engage in advocacy and raise public awareness, and provide advice for technical cooperation. So if everyone could just mute their sound, you can ask questions anytime using the chat function, which I'll be monitoring. And so I'd like to introduce our first expert we've got for us today. So that is Clement Voule. He's the former UN Special Rapporteur on the rights to freedom of peaceful assembly and of association. So he's joining us very kindly from Togo today. I'd like to hand over to him now. Thank you, Clement.
Thank you very much. And I want just first of all thank staff for the invitation to talk about the accountability mechanism, which one of them being the special procedure set up by the United Nations Human Rights Council. So let me quickly share my screen and I'm not sure if I have the right to share that. You can see. Sorry, Claire, but I think I should be, yes, okay, that's fine. Can you hear me properly?
You should be able to share it, Clement. If you want to email it to me, I can put it up as well.
Yes, you can supply, have it here. I don't know why it's not coming on my screen. It should open on my screen. It should be ready to come. So that's. No. Okay, so I'm sorry, let me send it to you then because it's open here, but I can't see it on my. Can you see it now?
Yep, that's perfect.
Okay, thank you very much. So, sorry for that. Let me just quickly introduce the UN special procedure for you, which is one of the accountability mechanism within the United Nations, because we have also others that are treaty bodies, commission of inquiry, but what we want, as you mentioned here, focus on is really the independent mechanism set up by the Human Rights Council. The first question is, who are they really when we talk about the UN human rights procedure or independent experts within the UN? First of all, let's say that there are a specific mechanism that is set up established by the UN, and it's always through a resolution adopted by the United Nations Human Rights Council, which have his proceeding in Geneva, and currently their session is going on. We have in the in the council or in the whole bodies or UN special procedure, we have two different categories. The first one being the special rapporteur or thematic mandate, the special rapporteur dealing with thematic mandate, which we call generally special rapporteur on thematic issues. And we have also country issues. But among also this mandate, the thematic mandate, you may also have mandate that is carried by one individual or mandate that is carried by a group of people. We have, for example, when it comes to the country mandate, like for example, the special rapporteur on Myanmar, so we call it country mandate, or special rapporteur on Burundi, or independent experts in CAR. So usually you can see the name special independent expert or special rapporteur. The mandate is quite the same when it comes to the country focus. You have also a group of experts. This is what we call a working group on discrimination, working group on extrajudicial killing. So we have also those type of mandate that is carried by 5 people, not only one person. We have also within the UN system, besides this division, like I mentioned, some of the thematic mandate can be carried by one individual, some of country mandate by one person, but also some of the thematic mandate by a group of persons. The special rapporteurs, they are always appointed by the Human Rights Council, and they are unpaid people. And they are appointed through a process of selection where Human Rights Council or Office of the High Commissioner advertise the position, and you apply, and based on your own experience and your knowledge in this particular subject, you may go through the process, which is the process that is handled by the states, by the group of ambassadors, until your appointment. And when you are appointed, you can only stay in this position a maximum of 6 years. So in general term, what is their main function? The special rapporteur, in general term, undertake country visits. They receive communication, which we are going to talk about now in the coming in the following slides. They also engage with state and non-state actors. They contribute also to the standard setting, awareness raising, technical advice, and also they also are set up to also make sure that the mandate or the concern of the citizen are taken into account by the UN. The reason why this special procedure exists, and from my perspective, is also because UN as a body is sitting in Geneva, and UN need also to be present, because you remember that the reason why the Human Rights Council is set up is to be able to deal with all human rights violation situation and human rights concern in the whole world. But they can only deal with that if the Human Rights Council have presence or have people that are able to be on the ground and to engage and to be able to collect information and to inform the council about what is going on. Let's see the example of the mandate that I hold before, which is the special rapporteur on the right to peaceful assembly and of association. You can see here that the mandate first was established by this resolution that you can see on the screen on the screen here. I don't know if you can see that. So 60/15/21, and the resolution also highlights what should be the mandate or what the special rapporteur is mandated to do. The first thing, for example, in my case and in general, for many of the thematic mandate, is to gather all relevant information on the concern of the mandate. If you look at mine on freedom of association and peaceful assembly, to study a trend, what are some of the challenges that this fundamental freedom is facing, and to develop and also to make a recommendation in relation to how the UN Human Rights Council states and other agencies can take a positive step to be able to overcome some of these challenges. And then also to seek, receive, and respond to the information from governments, non-government organizations, and this can be the case of communication coming to the special procedure on some of the key violations. But also one of the things that is important is that to be able to inform the Human Rights Council about the violation that the special rapporteur is observing. And this can be through, again, communication, press release, or through also country visits. But we will, let's also dig a little beyond that. And in order to be able to implement this, we developed certain sets of method of work. And some of our method of work is every mandate should submit 2 reports every year. Mandate, either you can be country or you can be depending, because the resolution will always highlight clearly if your mandate will submit a report to the Human Rights Council, but also to the General Assembly. And the annual report generally, in the case of my mandate, for example, I'm allowed to submit 1 thematic report to the Human Rights Council, but also to the General Assembly, but also to undertake country visits, to also send communication when I receive information from people that their rights are violated, that because of the land disposition, there have been a protest that was repressed by the state. I can now engage with the state through a communication procedure and inform the council at the end on what are the key steps taken by the state to correct or to mitigate this violation, but also to engage publicly with different stakeholders on the mandate and also the substance of this mandate. For example, what I'm doing here is also one way to engage with public and to inform about the mandate and to encourage people also to contact the mandate when their rights are violated. The main method of work, I mean, if I may say that in terms of one of the main methods of the work is communication procedure, which also is good, is interesting for many of your participants. How do you really engage with the special rapporteur? How do we contact them? The first thing is information. When your rights, in the case of the peaceful assembly, your rights, you have been repressed or you have been prevented to protest, you can then send a communication to the special rapporteur. We call them information that you send to the special rapporteur, and then the special rapporteur will cross-check those information. And the cross-checking the information means also that you can contact some of the UN agency on the ground to see if at this particular time there have been a protest, if at this particular time the protest was repressed, and also other entities like NGOs, diplomatic community. You need to cross-check this information to avoid that you act on the information that is probably misleading. Because as you know, many states are quite very, very careful in terms of every time that any mandate send the communication, the first reaction for many states is that those information are not true. So the mandate holder to cross-check this information, and it's clearly laid down in our code of conduct that always the mandate holder always seek to establish the facts based on objective, reliable information emanating from relevant, credible source that they have duly cross-checked to the best extent possible. So we need to cross-check all of this information. And then when we cross-check this information and we have evidence that the protest happened, this protest was repressed, then we can decide now which kind of letter we will send to the government. It can be a letter of allegation, which state that, okay, this violation happens. It can be an urgent appeal, meaning probably that somebody is arrested and during the protest and may be killed. So we can decide which type of communication to send. For example, if the information is based, for example, on legal reform that may undermine the rights of people to protest, then we can decide, for example, to send what we call in our own language order letters, which are the letters that analyze the framework in the country and make recommendation to the state or to the legislature in terms of what really to change in the law in order for the state to comply. So all of these methods, you can see them on the UN the website, but also the special procedure manual of operation. And when you send this communication, it's always important also to be quite precise on the fact, when, where, who, all of this. You can see the form on the UN website. All of this is also to ensure that the special rapporteur can act quickly, because one of the things that is important also to distinguish between the special rapporteur, treaty bodies, and other mechanisms is that the special rapporteur can act quickly within maybe 3-4 days. The special rapporteur can issue, which is not the same for other, because you have to go through a process that is more a lengthy process, or is more longer than the special rapporteur. And another thing that is important also is the public and press statements. It's one of the tools that, when, for example, and it's clearly laid down in our manual of procedure, saying that when, for example, you have evidence that there will be a harm or there will be a violations, you can also use the press. When you have evidence and you have been engaging with the state is not doing anything, you can also use the press release as an additional tool to pressure the government to take a step to be able to correct or to mitigate this violation. And in our manual of operation, it's clearly the state, and this is what I put, inappropriate situation, including those of grave concern, or in which a government has repeatedly failed to provide a substantive response to communication, a special procedure mandate holder may issue a press statement, other public statement, or hold a press conference, either individual or jointly with other mandate holder. So this is an additional tool that we use when we think that the government is not doing anything, and we want also to be able to inform the international community of the failure of study the trends. And in order to implement this mandate, we issue every year 2 thematic reports. And the process for this thematic report, where you can also participate as a civil society organization. The first thing that we also, in most of the special report or thematic one, is the call for inputs. The call for inputs are important because they also allow everyone, states, agency, to be able to provide substantive information for the special rapporteur from their perspective and from their experience. And when, for example, I want to do a report on climate justice, I will then send the call for input for states and ask them, what are your experience? What is in your country is putting in place to really ensure climate justice? Civil society is the same. Usually, these are the tools and opportunity that I always advise people, those who are working on the issue, to take this opportunity to be able also to send their input. Why? Because the special rapporteur, the report that will be drafted will go to the UN and it will become public. So then you are able also to see some of your contribution and some of the positive work that you are doing to be able to work through the UN processes. And then you may also, after the call for input, you may also decide to organize in-person consultation or online consultation. And after the online consultation, then after collecting online consultation and input, you start now the process of the drafting the report, and you will then submit the report to the UN, and you will be given opportunity to present these reports depending your schedule, either in March, in June, or in September. some of these thematic reports that I drafted when I was a special rapporteur are here. They're still important and relevant for today. I'm not going to go through them one by one, but some of them that are probably key that I want to remind you is one of the reports on the climate justice, where I highlight the importance of the state to ensure that civil society, communities, marginalized groups that are protecting climate can be protected also. So in this report, I argue that without the participation of civil society, we will not reach climate justice. And then another one is also how to advance accountability in the case of violation of human rights, in particular, the right to freedom of association and peaceful assembly. It's important also to look at this report. And my last one before leaving the office was a model protocol that I drafted upon the request of the Human Rights Council, which it's actually the model law for the law enforcement on how to facilitate peaceful assembly in compliance with international standard. Another method of work, action that we do quite is a country visit. And as you know, the country visits is at the time for really special rapporteur to discuss with state, communities, those, the victims, and to be able to understand better the situation in particular country. And the country visit, before the special rapporteur undertake the country visit, the special rapporteur need an invitation from the states. And some states may have an open invitation. Is then the situation where the state, for example, send within the UN, say that I'm open for any visit. However, even with the open invitation, you still need the state to confirm or to send you an invitation telling you that in this particular time, I'm asking you, or I am open to receive you as a special rapporteur to analyze the situation of which you are dealing with. And in one thing that is important to highlight in a country visit is that it's the time where a special rapporteur have the possibility to meet with a state high-level of people, but also the time also that state can, the special rapporteur have the possibility also to influence the state position, because being able to see what is happening on the ground and also inform the state and make the recommendation. And after the country visit, you have, for example, as a special rapporteur, the possibility also to issue what we call the preliminary recommendation. And after the preliminary recommendation, and draft the whole report and make a recommendation to the government. We can maybe discuss that. And this report is also presented during an interactive dialogue in Geneva. Another thing, here I provide some of example of the country visit that I conducted: Armenia, Tunisia in 2018, Sri Lanka and Zimbabwe in 2019, Niger in 2021, Brazil in 2022, Peru and Algeria in 2023, Bosnia and Herzegovina in 2024. And as you know, during the COVID time, we were not able to conduct country visits. So that's why I put the 2 country visits that I was not able to conduct in red. What is important to highlight here with country visits, that in the absence of the country visits, it's also possible for civil society, for the community also, to invite the special rapporteur, either through an organization like yours or National Human Rights Institution, to come in an academic visit and to discuss with communities about their concern, and not use those information also in his activities, on her activities, such as when sending the communication or when, for example, drafting a thematic report. I'm not sure if I still have some time before closing, or I'm running out of the time already.
We're running a bit behind, but yeah, if you just got one more slide, that should be fine.
Just to conclude, what I want to say here quickly is that you can see from, we didn't have time really to go in depth, but one identity of the special procedure is that because they have this capacity to act quickly, and because they are head by an independent experts, they are head by a group of independent experts, the special procedures are one of the relevant mechanisms within the Human Rights Council that is able to inform timely Human Rights Council about what is going on in the world. And that's why they call them within the Human Rights Council the eyes and ears of the council, because we are present. Because you can go from Australia, you can visit Australia. I don't know, in 2 months, and then being in Togo here, visiting Togo in another 4 months. So meaning that the special procedure and the independent expert, because they are going around the world, they are able to see every day what is going on around the world and inform timely. And they are also the mechanism that deal with human rights issue quickly. And they are also the mechanism that I think, from my experience, they are the best early warning that Human Rights Council have within his system, where we can alert the international community about what is going on either through communication or through press release or through the report that we present twice a year. So I want to also to end there by thanking you for giving me the opportunity also to present, to share quickly, and I will be happy to reply or to clarify any question that you may have. Thank you very much.
Well, thank you for that presentation. That was great. I'd like to remind everyone we're going to do questions at the end. So if you do have any questions, feel free to pop them in the chat. But we'll just move on to our next presentation now. So we're going to be hearing from Professor Ben Saul. He's the current UN Special Rapporteur on the promotion and protection of human rights and fundamental freedoms while countering terrorism. So over to you, Professor Saul.
Thanks very much, and good evening, everyone. I'm delighted to follow my dear friend Clement, who I saw just a few weeks ago in Geneva, of course. And Clement is a veteran of 6 years as a special rapporteur. I'm still very new. I've been in the job about 18 months, and I can say that Clement has been a hugely respected part of the special rapporteur team over many years, and I've learned a lot from him, and he's been very helpful to me in with my visits to Africa at the end of last year, including Benin and Côte d'Ivoire. Look, I'm the Special Rapporteur on Human Rights and Counterterrorism. My mandate was established about 20 years ago, soon after the terrorist attacks of 9/11. And it was really in order to push back against the excessive counterterrorism policies adopted by many countries after the 9/11 attacks, and to try to encourage states to be more respectful of human rights while countering terrorism, not only because it's their legal obligation to do that and because it's the morally right thing to do, but also because it makes counterterrorism more effective. If you respect the boundaries set by human rights law. My mandate looks at obviously state violations of human rights while countering terrorism. So that includes violations against both people who are genuinely terrorist suspects, but also what we in fact more commonly see, which is the deliberate abuse of counterterrorism law against a whole range of people and organizations who aren't terrorists at all. So the misuse of counterterrorism law against political dissidents and human rights defenders, journalists, media organizations, minority groups, students, universities. I mean, the list goes on and on these days. The mandate looks, it's a cross-cutting mandate. So Clement introduced some of the types of mandates. Some of the mandates just look at a single issue like torture or summary executions. My mandate tends to span a whole range of violations. So what we frequently see is arbitrary arrests and abusive prosecutions of the kind I just mentioned, denial of fair trial, torture, mistreatment in detention, summary executions, violations of humanitarian law and armed conflict against terrorist groups, violations of the principle of non-refoulement, so returning people to persecution who are suspected of involvement in terrorism. And we really span the whole range of state action. So police, intelligence, security agencies, border security officials, people who work on prisons, people who work on preventing, countering violent extremism. The mandate also has a few extra parts. We also look at the rights of victims of terrorism, so trying to encourage governments to support the victims and protect the victims. I monitor the 47 UN agencies that are involved in counterterrorism based through the Global Counterterrorism Compact in New York. And then, like Clement, undertake communications, country visits, thematic reports, and so on. Next country visit will be to Somalia in just next month, actually. Now, Clement has set out very well the sort of the job that we do. So what I'd like to focus on briefly is just saying or making really a few practical suggestions about how you can utilize the system of special procedures in your work. I'll focus on communications because that is often one of the most useful mechanisms that we can offer. I had a look, and in the last year, across the special procedures, we issued almost 700 communications to government. So that means both individual cases as well as reviews of new legislation, bills, regulations, etc. Of those, my mandate joined about 110. So I think that indicates just how prolific are the misuses of counterterrorism law. That one in six, 1 in 7 of all communications has some kind of counterterrorism or counter-extremism angle to it. In terms of the process, we've put in the chat the sort of the website which gives you information about how to request a communication. But really, there are a few key suggestions I'd make. Number one, normally the consent of the victim or their legal representative or their family member is required for us to bring a communication on behalf of somebody. That's to ensure that their participation in the process is voluntary and informed, and that we don't endanger people by naming them if they don't want to be named. So in thinking about bringing a communication on behalf of individuals, you do need to obtain consent and provide us with the consent. There's just a very simple one-page form we provide, on which you can give that consent. And it is important to think about what are the risks of bringing forward a communication. So, would it make the situation worse? Would it put the victim or others associated with them at risk of retaliation or reprisal by a government or indeed a non-state actor? If that is the case and there are concerns about reprisals, then it is still possible in some cases to bring communications without naming individuals. So if, for example, there's a pattern of violations against a whole group of people, a community, we could still bring a communication where it's not necessary to identify a particular person because the human rights violations involve a much larger number of people. If you're bringing requesting us to bring a communication, I'd suggest you provide as much factual information about the situation as possible, so that we don't have to go back and forth trying to seek enough information to bring the case. Try and identify what you think are the kind of key legal issues. So what are the human rights violations involved? What do you want out of the process? So what kind of remedies or relief are you asking for? It's important also to identify which mandate or mandates you'd like to bring the communication. I say that because sometimes, we get a letter from people addressed to, a long list of 10 or 12 mandate holders. And sometimes there can be a kind of tragedy of the commons problem, where we all think somebody else must be taking it, and so in the end nobody takes it, or there's a lot of confusion about who should be leading on it. It's absolutely fine for a whole bunch of mandate holders to join a communication, but someone has to lead it and draft it. And so trying to sort of work to identify who would be best placed would be useful from our standpoint as well. Bear in mind also that special procedures. We've got acutely limited resources. So a mandate like mine covers 193 countries. We also write thematic reports and country visits and do a whole lot of stuff in between. And I have one staff member paid by the member states of the United Nations in Geneva to do all of that with me. We rely a bit on some voluntary assistance here and there as well, but our mandates mostly are much smaller than even a small NGO working on a single issue in one country, right? So we're pretty stretched. So when we decide what kind of communications we'll take forward, we take into account, is this issue does it raise a kind of novel question, which we haven't addressed before? Is it, a systematic or a large scale problem? Would we be able to make a difference through this communication? Are there other human rights procedures which are already looking at the question, across the broader human rights system? Have similar communications been brought before and the issues already addressed? So look, even if your communication would be absolutely full of merit and we'd love to take it on, sometimes we're just not going to be able to do that. In terms of the advantages of bringing a communication, to add to what Clement mentioned, we can respond quickly compared to, say, the treaty bodies, which are a much longer process. It's a pretty simple, straightforward process to send the information on which we can base a communication. You don't have to exhaust domestic remedies, go through national courts like you have to do, say, for the Human Rights Committee or the Committee against torture. Our mandates are, diplomatic positions, so we've got very good access to governments, and we are, through this process, often able to get more information from governments about what's going on in a particular case. It can also prompt a constructive dialogue with the government, and if that doesn't work, we can then go public at the end of the process through press releases, media, etc. We find that our communications, once public, are often very useful to NGOs and lawyers and victims for use in their advocacy as well, because it provides them with ammunition supporting their case as well. Communications can influence judicial decisions. Just last year, some of the work we were part of was cited with approval by the International Court of Justice in the genocide case, by national courts, by regional courts. So they can have ripple effects above and beyond just the immediate contact with the government. We're also independent experts, so we're not UN staff members or officials, and that gives us, I'd say, a bit more freedom in that we're not bound by UN positions or policies in the same way that other parts of the UN system are. So we can be sometimes quite progressive in the positions we take in advancing human rights law. Governments do take the process pretty seriously. I mean, governments respond about 50% of the time to communication, so respond in writing. And then on top of that, often, I'll meet with governments, even if they haven't had a written response, and we'll have a dialogue about the case in any case. Sometimes violations are inadvertent, so it's a lack of capacity or knowledge or legal frameworks on behalf of the government, and so there can sometimes be goodwill to fix up those problems, and we can work with them to remedy those situations. Governments are complex, they're made up of lots of different actors. Sometimes the bit of government that is violating rights will be, quite different to other bits of the government that are keen to ensure respect for human rights. And so you can often identify and work with champions of change within government to work with other actors in government to improve their behavior. When I talk to NGOs, they, I always ask, is this process useful or is it a waste of time to you? And often I get quite useful feedback. One NGO told me even a tweet from a special rapporteur can make a difference to the way that a person is being treated by national authorities. The sense that there's a kind of an international watchdog looking over a government shoulder can sometimes make a difference. I heard one story of guards in a prison in Southeast Asia being overheard by prisoners talking, saying, look, we're really annoyed. We can't beat up the prisoners anymore because the Ministry of Foreign Affairs came to us and said special rapporteurs issued this communication, and they're really concerned that we're not to be seen to be torturing people anymore. Families of dissidents in one Middle Eastern country stopped being harassed and intimidated by governments. They told us after special procedures intervened with that government. Now, look, at the same time, you've got to be realistic about what the process can achieve. It's not a binding decision. It's not a judicial decision. There is no obligation on states even to reply, although it's good practice to do that. And even if they reply, of course, they don't necessarily agree that they violated or will agree to change their behavior. The process is it's different from the treaty bodies, because with the treaty bodies, the victim presents their case, the government responds, and then the treaty body, like the Human Rights Committee, makes a final, authoritative quasi-judicial decision. Our process doesn't go that far, so we present allegations, and then the government responds, and that's really the end of the process, apart from maybe some media and some ongoing dialogue with the government. But we don't make a kind of final decision in the manner of those other bodies. In presenting allegations, we try to verify the information we're given, but because of our resource constraints and because we lack fact-finding capacities on the ground, we do rely a lot on the information we get from the victims, and that may be wrong, it may be self-serving, it may be distorted, and so the process will not always reach a kind of objective conclusion. Sometimes communications can also provoke reprisals. So governments can absolutely be angered by being exposed on the international plane. Lots of governments, of all, in all regions, global South and Western, are pretty thin-skinned, actually. They do care about their reputation. They don't want to be called out on it by a high-level procedure like this, and that can sometimes make them take it very seriously and change behavior. Other times it can make them dig their heels in, and things can potentially get even worse. So look, just to wrap up and throw to questions, I'd echo Clement in just encouraging you also to participate in our other work. So consultations in the lead up to or during our country visits, if that's relevant, as well as the calls for input that we issue before drafting our annual thematic reports to the Human Rights Council and the General Assembly. That information is extremely valuable to us, even if we don't always cite it in the report, because reports have very strict word limits, and we can't always acknowledge all the information we've taken advantage of. But rest assured, it is read, and it is absolutely important in informing our work. And the final one is just, we also sometimes intervene in court cases through amicus briefs. So that's another way you can encourage us to get involved. If you're involved in strategic litigation in a particular country, you can always think about asking us to get involved in that as well. So look, I'll finish there, and back to you.
Thank you so much for that presentation. So we'll just do a couple of questions now. So I've had some rolling in throughout the presentations, which have been great. So the first question we have is, who decides at the United Nations system or at the Human Rights Council when to start a special procedure, and who controls the Human Rights Council? If either of you would like to jump in.
Yes, thank you very much. If I understood well, who controlled the council and who decided the establishment of the special procedure? That's
Yeah. Who decides when to start a special procedure?
Yes. In terms of who controls the council, as you can, let me be clear. The council is still an intergovernmental body, meaning that the decision is taken by states, by the representative of the state ambassador. And as you can see also, the president of the council is always an ambassador. And the bureau also, they are all ambassador or representative of their country. So in terms of who controls the council, is the states, is the intergovernmental body. But how the process of establishing, who decide? In most of the cases, this is what we call advocacy. It starts with advocacy. For example, when you think that there is one issue that is important, which is not covered within the UN by no mandate. For example, let me just say this. In terms of democracy, you think that there is no special rapport, democracy is under threat in the world, and you think that it's important to reinforce that. You may also start by lobby some countries, because there is countries that will propose a resolution. All the mandates are always established by council resolution. Both when we talk about the mandate, we are talking about also, just to make sure that there's no confusion, you have the mandate holder, which is appointed also through the resolution for 3 years, renewable ones, but you have also the mandate itself that is established for also every term is renewed 3 years. So it's important to separate these things, because the tenure or the period of the mandate holder is not subject to the period of the mandate itself. The mandate holder, it may also happen that a mandate is end when the mandate holder still have his tenure going on. So it's possible. So just to reply to this question is also to say that you need to lobby when the country, and then the group of countries, usually it can be cross-regional countries that you bring on board and trying to sensitize them about the subject. And if they deem that this is important, they can then start the process within the council to suggest a resolution for the creation of the mandate. And today, let's be also honest, because of the funding restrictions, as you know, the creation of every mandate, it goes always with what we call a PBI, meaning that the cost programmation of the mandate. Because of the funding, many states are more reluctant to create new mandate, because some of the mandate that exist today are still unfunded. However, this is always also political decision, let's be clear. There have been a recent creation of recent mandate, including on Russia, on others. Some states may say, okay, we are able to fund it, and it can be also political decision that we want to create it because we think that the situation in this country is a particular concern, and we want to put additional resources to be able to create this particular mandate.
Perfect, thank you. So our next question is, does the Security Council have any veto powers over the Special Rapporteurs?
Sorry, Ben, you want to take this one? Or?
Yeah, sure, no worries. No, short answer is no. So the members of the Human Rights Council are the ones which appoint by consensus the mandate holders. So as Clement suggested, I mean, one of the good things about this process is that it is supposed to be a merit-based appointment system. So unlike quite a few other bits of the UN, which are appointments based on horse trading for votes between nominees presented by governments, who governments then campaign for, we apply in our own right as independent experts. There's then a committee which looks at those applications, conducts interviews, and then makes the recommendation to the council, and then the process is appointment by consensus. So there's not a vote as such. Just to go back to my and so yeah, it is insulated from the P5 politics in New York. At the same time, of course, a whole lot of politics, to an extent, goes on behind the scenes in terms of ensuring that there is that consensus. So if there is any particular controversy about particular candidates or political issues, occasionally that might play a role. It's just very opaque, and we wouldn't necessarily know about that. On the previous question, yeah, look, my mandate is up for renewal tomorrow. So the last day of the current session of the Human Rights Council in Geneva. Countries have been fighting for weeks about what the language of that resolution will be, how much financial support they want to give to it. So this is, as I said, my mandate's been going for 20 years, but every 3 years, it comes up again, and the process is looked at afresh by the member states. Hopefully, I'll still have a job after tomorrow, but it's I think I'm safe, but you never know in politics.
Yeah, perfect, thank you. So the next question we have is, if a state refuses entry to a special rapporteur, are they able to visit that country on an unofficial visit?
Well, yeah, there are a lot of cases where states will reply to the special rapporteur and say, it's not the time for you to visit because I'm going through this national process, or just to say that I don't want to receive you, the case of Iran. For many rapporteurs, but there is no way that you can enter in the state without the consent of the state. However, in some of the countries, you may also go what we call academic visits. And meaning that during these academic visits, you can also discuss, meet victims, meet other stakeholders, but the only thing you can do is that you are not allowed to present a formal report to the Human Rights Council. So you can use some of this information in other type of work that you are doing, but you cannot use it as a formal information. Yeah, so that's what I can. I don't know if you have something.
No, only that sometimes countries will say yes to a visit and then never get back to you with dates. So I've got about probably 5 countries in that category. Some of them going back 4, 5, 6 years. Who in theory are open, but in practice, it's a yes sometimes means no, actually.
Of course, thank you. So I think this would be a good question for both of you as well. So I might start with you, Clement. How can civil society organisations and grassroots activists collaborate more effectively with the UN Special Rapporteur's Office to report human rights violations and push for urgent interventions?
Well, the first thing that I always advise is please, the special rapporteur have this advantage that they are close to people. It's not UN, we are not in one of the Bible. I mean, when I was in the mandate holder, I was in Geneva, in Togo, Benin is Australia. We are all over the world. So we are not really one place that we are, the door is closed on us. You have to ask so many permission before. So we are very accessible. The first thing is that please ask, be in contact. Either you ask in the special rapporteur, we would like also to have an online discussion with you about what we are doing and which is relevant for you. And whenever you have a situation in your country, and you don't know, you don't have you don't know how to draft a communication or whatever, I always advise that send this information to the special rapporteur. And probably his staff will come back to you and say, can you submit a communication? Because this is important. And they can also guide you. Because I know some of the people, they will say, oh, we are not a lawyer, we don't know how to do it, it's complicated. No, they can also guide you and say, please fill this form, do this, do this, do this. And this is the first thing, communication, sending the information, but also the call for inputs. When we launch call for inputs, and what I was mentioning also, is in some of the cases, states want also to see through our report, what are some of the promising practices. And if your organization, you are doing something on accountability, for example, how you advance accountability on particular issue, on indigenous case, at the domestic level. These are important, for example, to also work through our report and to show the Human Rights Council how some of accountability is handled in national context. It is also important. And also, you can also, I also advise, for example, inviting the special rapporteur on not necessarily an official visits, but also, I mean, official visits, they had to be the state, but also academic visits, where you have time also to work with the special rapporteur, to take the special rapporteur around, to meet communities, to meet also indigenous people, and for himself also to be able to be familiar on some of the challenges that the community are facing.
Yeah, perfect. Ben, did you have anything to add to that?
No, I think I pretty much covered that one in my presentation already. Thanks.
Perfect. So just in the interest of time, we'll just do one more question. So we'll go with, do either of you think any reforms are necessary to keep your mandates relevant, considering some human rights violations by the UN Permanent Security Council members in today's society?
Look, for me, the biggest one is just the kind of crippling lack of resources, which in some ways I think is absolutely deliberate on the part of member states. You know, on the one hand, they mandate us to do all these activities, but on the other hand, don't provide us with anything like the level of resources necessary in order to do that. Now, we're on, mandate holders are unpaid volunteers, and that's fine by us. But you need a staff of a decent size, and a travel budget, which frankly I don't get, other than to present my reports and do my country visits. And so it's very hard to have the impact that you would like to have when you've got one staff member paid for by 193 countries who have vast resources and could easily provide us each with a slightly larger but nonetheless still small and pretty cheap team in order to do our job. It just means we can't help all the victims we'd like to help. It means we've got always a huge backlog of communications, which we can never possibly work through all of them. It's also difficult for civil society because there are expectations that we may be able to help, but because of resources, it's impossible. Let me just give you a comparison. I've got, as I mentioned, I've got one staff member. The counterterrorism monitor in Australia, so the independent reviewer of terrorism legislation, covers just one country and just the laws, doesn't take individual cases, doesn't do country visits, thematic reports, etc. Has a staff of 10, an annual budget of $2 million. I'm meant to be doing that for the world, and my budget is probably a couple of 100,000 and one person. So look, there is a certain sense that states want these procedures to be cosmetic and ineffective. We do our best to make sure that's not the case, and we are very grateful to sometimes get philanthropic support, some extra budgetary contributions by friendly states. We get lots of free labor. You know, it's probably modern slavery, frankly, from student law clinics and other volunteers. But it's, you know, it's clearly not enough.
Yeah, Clement, did you have anything to add to that?
Yes, if I can chip in, and I mean, I second really what Ben just said, and just to add also that being a special rapporteur is really a commitment. I mean, because if you look at the amount of the work that you have to do with nothing, with no budget, with a small budget, but also human resources, the lack of human resources, and it's sometimes just like disappointing. But because you believe on what you are doing, you believe on this, right? You have to do it. And one thing that I want also to highlight is that it's not because there is no resources, because of the independence, our free mind speaking. There's many states that do not want to see within the system some independent expert that can speak from the mind, can also challenge them, because we are also able also to question sometimes certain things that the UN is doing on the ground, even if we are part of the UN, but we can question them. And you can see so many cases where you have even the UN system, a formal one, a Secretary General, it cannot say anything about, we can say it about. And sometimes we receive those some of the states like Russia, US, asking us why you are talking about these issues. Why, and then sometimes question our independence or our relevance. And I think, Ben, if you agree with me, that our strengths and our relevance is the fact that we are really connected to the communities. We are connected to the victims. And it's one of the systems where you can see always victim oriented action is so strong. And I think this is why we still, and the system is still, the special reporter, the special procedure system is still alive. There have been many instances where states want to put a resolution to stop or to destroy, to undermine our independence. But we survived through all of these years, thanks to civil society, thanks to the victim that continue to see the relevance of the system and come into the system. And I think we are the one of the entity that receive more, like Ben mentioned, the communication. We also have we also have more reports. Just go through the COVID time and see within the UN entity, which entity was able to call state attention on the violation of human rights within the COVID time, or call attention of the state to take care of the community. It's a special procedure where many states were not able to say anything, or many entities were not, within the UN were not. We have been in front line saying things, providing. And this is what is causing us sometimes the lack of resources, because some states, they are reducing our budgets every year. They are also attacking our independence. But thanks to you and to your work, making sure that we are known by communities, we can be able to connect with communities. We are continue to survive for you.
Oh, well, thank you so much, and I'd like to thank you both for your time today. It was really appreciated. It was fantastic presentations from both of you. We've run a little over time, so sorry about that, everyone. But I'd like to hand back to Claire from Starts.
Hi, thank you, Claudia, Clement, and Ben for your presentations. On behalf of both DTP and Starts, we really appreciate your time and being able to share with our participants your experiences and knowledge in your various mandates and the work that you're doing in the special procedures as a whole. You explained it extremely clearly for everybody about what the procedures are and how they're able to engage with the procedures themselves to be able to assist their causes and the issues that they're working on. So thank you both very much for your time this evening here in Australia, this morning for you, Clement. This webinar brings to an end our UN Human Rights Accountability Mechanisms webinar series. All of them are available on the DTP website, and I'll share a link with that for you later. The next series that we're doing is 3 on the Magnitsky Act, and we'll be starting that in May. So we'll email everybody with information about that once those webinars are registrations open. But on behalf of DTP and STARTS, I'd like to thank all of you for participating today, and I hope you have a good rest of your day.
Thank you very much.
Thank you.
Thank you, Ben. Also, thank you.